We take you there now to the Mthatha High Court, where the matter is being heard. And of course, that application brought forward by the students from Walter Sisulu University.
And that is the case that we are making. And the second issue, my lord, is the issue of irreparable harm. That if this interdict is not granted, self-evident, my lord, that the students will be thrown into the streets. And there they'll be exposed to criminal activities. Who knows what might happen? The rape cases have risen in our district. It's just unimaginable, my lord, what would happen if you take young students such as they are thrown into the streets with their belongings.
Yes.
So the alternative remedy, my lord, well, there isn't any alternative remedy. They are being evicted. Those who reside in distant areas, they haven't been given an opportunity.
So essentially your submission in a nutshell is that you've met the requirements for the relief you seek.
Yes.
I see. Anything else?
My lord, no, there's nothing else. My lord, I feel the need to also, just to clarify the issue of the balance of convenience,
yes,
which is also paramount with regard to the issue of an interdict. My lord, let's say that it's a respondent's case, my lord, that, my lord, apologies, I can't really assist the court thoroughly on what the answering affidavit states, because I only received it once during the court.
Yes.
However, I appreciate how the court has assisted me in engaging
yes,
what the real issues are in the answering affidavit. The issue of protest action, my lord, is that, well, an undertaking can be gathered from the students not to engage in protest action. But they've also stated, my lord, that, well, to dead on deaf ears, the status quo is that the university is closed. But they will only enjoy the facilities provided by the university in order to engage in their educational activity.
The university, if I may ask, why is the university closed?
My lord.
Let me perhaps put it this way, and I hope Mr. Genugile will assist. The letter that the notice indicating the closure of the university seems to be saying the students are required to vacate campus by end of business of the 18th of April. And then it talks about online, and then the IT support, and it talks about the last paragraph, the university management working on the issue that led to this situation. So the issues that led to this situation. And I'm not sure, those are not stated. I don't know what that means.
Vague. It's vague, and that is the letter that is being implemented. It's extremely vague to its recipients. We can only assume what it means in the face of it. And perhaps my little colleague has tried to cure the contents of the letter to the answering affidavit, but not every student who suffer the consequences of this letter are privy to the contents of the affidavit.
I see. All
so
right.
It's extremely vague.
All right.
And that statute makes provision. Let's say, Madam, we extend the definition of closure to eviction.
Yes.
Even the implementation of this then would be irrational because we need to provide reasons as an administrator
yes,
of how your decision is rationally linked to the statute in which you are implementing.
yes,
But not that such reasons are furnished.
I see.
And the assumption, my lord, could be that recently a student was shot in the campus of Walter Sisulu University. But the perpetrator of that one was a res manager who was employed by
the first respondent.
The first respondent.
Yes.
So you can't, and they've dealt with that, the authorities have dealt with it accordingly.
Yes.
The person who's perpetrated the possible murder is now in custody.
Yes.
So the threat is no longer there, at least up until he's granted bail, which will only be on Tuesday. So
well, you may not have noticed, but Mr. Genugile seems to suggest in his papers that further violence has taken place even after that incident, that initial incident. If I understood his papers very well. Mr. Genugile, not so. are you not making a case that that was not the end of the violent protest or the violence that you say the applicants are perpetrating?
Yes, my lord. We're saying that the violence must not be streamlined to the death of that particular student.
Yes.
If you take into consideration the burning of staff members' vehicles, with stolen destruction of property.
If I may ask, in relation to the unfortunate passing of that student, when did the burning of the vehicle occur?
All of this, my lord, commence at the start, or commence right after what Mandela colleague terms and the students terms a peaceful protest.
Yes.
So all of this occur post the date of the 15th. They don't happen before that.
Yes.
So there's a protest or student unrest that all of these incidents occur during such course of student unrest.
Yes.
Yes, ma'am.
But after that, after the 15th, did any violence take place?
Well, Lord, continue. If that my lord were to be the case, we would not find ourselves in a position where we still allege that the threat to university property still exists. This, my lord, is the reason that necessitated a letter to which we seek temporal closure under the 5th of May, because we hope that between now and that particular time, such issues will be resolved.
I see. All right. Were you done with your submissions?
My lord, we are saying that when we are implementing when we read the council resolution, seemingly it is triggered by the murder of that student.
Yes.
We are saying that, well, the person who perpetrated the threat to the safety of the students is now being eliminated because he's arrested.
Yes.
So the threat no longer exists. That is what they say.
Except that, of course, if would the burning of the vehicle be attributed to that person as well?
My lord, the burning of the vehicle occurred only after the student was murdered. Seemingly the students were demanding justice.
And so they should be understood to be entitled to burn vehicles as long as justice has not been done for the unfortunate passing of that student.
Another issue that I wish to highlight again, my lord, we cannot assume that those were students.
And that's the point that I was raising with you. When the students
We
do
can't
not
assume that the people who burned that motor vehicle were students, unless there's a student that was been arrested for engaging in any.
No, but isn't that part of the problem, though, Mr. Ngunyana? Namely, that the banning of that property happened in campus, and they want to be allowed in campus. And as Mr. Kenugile points out, none of these things happened before the 15th when their protest started, and therefore, if then they should be allowed back in, then there is this risk that they may very well continue banning, demanding justice for that student, and then continue destroying property. And that's the difficulty that I'm having.
My lord, before the peaceful protest alleged
Yes.
by the applicants here, there's been multiple other protests that were engaging. I mean, there were circumstances where the taxi drivers engaged in that strike, it's public knowledge, where they destroyed the robots. Those are not students.
No, I don't know about that, but what I do know is that in their answering affidavit, the university says it is during student protest that those robots were destroyed.
But my lord, then the university must mount a case to satisfy us that such students are those who remain in residence.
Anyway, anything else? Any further submissions?
My submission, my lord, would be with the issue of the balance of probability.
Yeah, you've dealt with that.
Then that's the plan.
Mr. Genoke, let me hear you. Are you still raising your points in limine?
Yes, my lord. My lord, understanding that there is a motion proceedings. One is to leave and die by the case that was made in their papers.
Yes.
you can at least establish two things. But the supplement of motion is not supported by any amendment in the founding affidavit, because these two things seem to conflict. So, understanding court processes, the relief that you seek must be substantiated in the founding papers.
Well, let me put it, then I don't understand, Mr. Gunugile, because the notice of motion says that they must not be evicted, essentially, from residence. And they explain in the affidavit why they should not be evicted. Are you saying that relief is not supported by the affidavit?
No, my lord, what they seek in the notice of motion is a final order in the form of an interdict.
Yes.
But they substantiate the founding papers as an interim relief. Whether or not it bears on the same line of thought, dealing with the issue of eviction, it has two different lines of jurisprudence to which it operates under.
Yes.
So that must be understood.
Yes.
So even if the consequence of what you're seeking may be the same, there is a particular way in which the law is being developed
Yes.
in order for one to accomplish that purpose.
Yes.
As indicated earlier on, but they seek in the notice of motion for final relief, of which they don't make out a case for a final relief in that case.
I hear that, Mr. Gunugile, but my difficulty essentially is that if one were to, for a moment, accept that what the students are saying is true, and that is, if evicted, they will be thrown out in the streets and they will be exposed to criminality, including rapes and murder and all sorts of things that happened in the streets of Mthatha. Should we then at this stage be spending a lot of time debating the jurisprudence of interim versus final interdict and on that basis say, well, if they die in the streets, so let it be, because we're busy with matters of jurisprudential importance?
No, my lord, that's not what I'm saying.
What are you saying then?
My lord, I'm saying the Lordship's standpoint is if they were saying, my submission is what are they saying? Those are two different things. However, we don't wish for the later segments of your Lordship for them to be found.
No, I'm saying, Mr. Gunugile, assuming for a moment I'm with you that there was inelegance in the draftsmanship, the papers could have been phrased better and all of that, and due to the urgency of the matter, a lot, the papers leave much to be desired. Assuming I'm with you on that point, now, should we not then go further beyond the legalities and say, but if the court sticks to the legalities and looks at the jurisprudence and say there are problems when it comes to those issues, and therefore the relief should not be granted, the consequence of that is that some of them may be exposed to what we know happens in the streets.
My lord.
Is that not so? Would that not be the consequence?
My lord, my submission is to this effect. And as I've said that the papers are not as desirable as they could be.
Yes.
Perhaps in my submission I'll then get in the merits as to what the consequence of that is to be.
Yes.
That being what they deny of the relief that they're going to seek and the consequence that go before you.
Yes.
Saying my submission is that the premise, the starting point is to accept that what they seek in the notice of motion has not been justified in their founding papers. And I said that is a motion proceedings. However, the consequence of that will then need or desire to be argued further. What I'm submitting is that the court must first accept that these being motion proceedings, the relief sought in the notice of motion is not supported in the founding papers.
I've already pointed out that you could be correct that these papers could have been drafted a lot better. I've pointed that out. I started there with Mr. Mgunyan.
Now, well, you note that my point in the M&A was running along the lines, again, of the principles of the jurisprudence.
Yes.
And the state resolution would have taken the point that perhaps the papers could have been better. The principle of subsidiarity falls along those particular lines.
Yes.
I, however, wish my first to deal with the contents or the merits of their case.
Yes.
my learned colleague seems to suggest two things. That the conduct that is empowered in terms of section 7.2 is at the exclusion of students, but the protection of students.
Section 7.2 of what?
Of the higher
Of the university statute.
Yes, ma'am.
I see.
Of which, my lord, if your lordship, I'll provide that, my lord, a copy later on. The correct reading of that particular section reads for the closure of the institution, provided, one, there is a threat to life, to staff members, students, and the property of the institution.
Yes.
So it is not that it excludes students from protection. So at a point whereby either the council or the vice chancellor identifies that there is a threat to life among the stakeholders of the institution, that would amount or necessitate the closure of the institution.
And you're saying that has been met?
That has been met.
Now let's look at the event that has taken place.
Yes, ma'am.
Have the students endangered any life in their action? I'm raising this with the context that the students are saying they have some of their number in hospital and one student has unfortunately passed away. And they say that was at the hands of the university and not at their hands. There is no case that seems to be made that they have attacked any staff member. Well, I didn't see it in the papers. You can show me.
Well, I'll show you, my lord.
Yes.
However, before we get to that particular part, the section itself does not say, in order for one to close the university, it must have been the students that are in danger of staff members.
Yes.
But it says, first, my lord, let me read it out for the record. This is, my lord, section 7, subsection 2M.
Yes.
Order the closure of the university in response to a life-threatening situation or circumstances such as natural disaster or threat to the safety and security of the students, staff, and property. So this entails that if any of these three stakeholders are in danger, not that they are aggressive, but at any point in time that there is some sort of threat to them, the students, the staff, and the property. So if the argument...
Let's say I'm with you there, that there has been a threat as described in section 7. You're saying based on that, that threat must entitle the university to throw them in the streets and therefore to be exposed to what could happen to them when they are in the streets.
No, ma'am.
What are you saying?
But that section says, in order to protect students, staff, and university property from whatsoever event is, students, the institution, through the vice chancellor of the council, may close down. And what we're saying, is that we're not saying go to the street. We say go home.
Well, Mr. Mguyana says when, how. He says some of them don't have money, some of them do not even have time, even if they have money, to make arrangements to be able to go home. And the question then is, while those arrangements are being made tonight, if the order is not granted tonight, they must be on the streets tonight. Where should they sleep?
Perhaps, my lord, the case of the applicant, in order to meet those particular concerns, ought to have been around the issue of the extension of the eviction process.
No, but that would then perhaps fall under the alternative relief part of it. But the question is, are you persisting that the students must be evicted tonight now? When I leave this court, they must be out of the university.
My lord, I mean, we are amenable to an order that provides an extension for the eviction.
Until when?
Well, that is what I need to then address now. Because two things. In accordance to our papers, the life of the students are not even safe at the campus itself as we speak. If one is saying there's a student that has been shot and died,
by a staff member,
by
they
a
say.
By a staff member.
You agree that it was a staff member?
No, my lord, I don't.
You don't?
It does not be made in the founding papers.
Yes.
There's no allegation that says this was done by a staff member.
Oh.
As indicated, my lord, that These are motion proceedings where we respond to the
the person I understood from the papers that the person that has been arrested is a staff member.
Yes, ma'am.
And I understand from the papers that that person has been arrested for the death of the student. Am I wrong?
Your Lordship is correct.
Yes.
Let's say, Lordship,
And so what do you mean when you say it's not a staff member?
No, my Lord, I'm saying.
He's just a suspect. That's what you mean.
No, my Lord. This is my submission.
Yes.
The status quo has proven that it is not safe to go on campus for students. Whether that data comes from staff members or otherwise.
No, that takes us to the next point then. If you agree that they are not safe in the campus and they are not safe in the streets, where are they worse off? Because we're dealing with their safety ultimately.
Yes, ma'am.
Where are they worse off, in the streets or in the campus? Because then it would seem to me from what you are saying that the balance that must be struck.
What we're saying, my Lord, incidents that have been reported and the situation to which your Lordship has been invited in accordance with the facts that have been reported on the basis that there's been harm to students, staff members, and the property of the university within campus grounds. If your Lordship is then saying, well, I then decide as the court, remaining in the institution with those circumstances, it is for your Lordship to decide.
Now let me ask you, should I then, the alternative is for me to say, get out?
The alternative, my Lord, understanding what the time that we are at today and the directive which precluded the eviction of students during daytime,
yes,
is for the court to provide an extension in terms and say, understanding that I cannot evict you at this particular point in time, taking cognizance of the time that we're before the court,
yes,
and also understanding the circumstances that you live in within the institution, I am to provide an extension for you to make arrangements in order for you to vacate the premise of the institution. Because one has to give value to the life of the students as it stands at the institution.
And the streets.
And in the streets. Hence I'm saying the alternative order to be granted is not for one to say their application is granted, remain in the same institution that you have just said has been unsafe for you to be in. However, the alternative is to then say, let me provide you an extension so that you can at least make alternative arrangements. That, my Lord, would be the
how much time do you need to do that?
Well, my Lord,
let me put it this way. In your letter, you say, your letter, I'm referring to the Vice-Chancellor's letter, there is reference to the university trying to deal with what has led to the situation.
yes, ma'am.
Now, I'm asking if that should not then include the university and the student community. Clearly, the university needs time. They say so in their letter. Maybe I'm trying to reach to this letter. The university management is working diligently to address the issues that led to this situation. I'm not sure I know what the issues that led to the situation, and to ensure that when the campus reopens, it will be a safer environment. I understand from the papers that the university has been closed until 5 May. Where is the letter? 5 May, yes. And today, what is the date?
We're looking at Lord, the date is the 18th of April.
18th of
April.
And how many days to the 5th of May, of April?
Plus minus 15 days.
Thereabout.
Yes, ma'am.
I see. And so if we agree that it would seem a fair balance is the one that allows the student not to be in the street where they are not safe, but to be in the university where at the very least they are entitled to be protection by the very university through its own security people. I would imagine the university has not given up in terms of ensuring that they are safe if they cooperate and work well with the university, if they don't misbehave or commit illegalities and all of those things. The question then is whether we should not be discussing, you should not be considering, you and Mr. Mgunyana, I'm not sure if structural interdict is the correct term, but something that ensures that we don't throw them in the streets, but the university property is not destroyed, while the university is trying to find a workable solution. Because you seem to agree that it would not be correct for this court to say they are on the street. They must see what they do, what they must see for themselves, because they don't belong there. The university is closed. Lectures are not happening. They must just see for themselves. Because you agree, you seemingly at least, that they could be exposed to all sorts of dangers. You accept seemingly that some of them come very far away. I'm assuming you are not arguing against that. You are not saying all of them are from around Mthatha.
Even not here as one of them don't.
You don't?
Yes.
Now, if it is so that there may be practical difficulties with evicting them immediately, without at least giving the university itself to do what it says it wants to do. In the very penultimate paragraph of its own letter, it makes it clear that it wants to deal with this situation, and that dealing with the situation surely must include ensuring that those who may not be able to go home remain at campus and are safe while they are there. I don't know if how many those are, but what I find it difficult is to say they must just be on the street and it's their problem. If they die, they die. That surely you can't be saying that.
I've not made that submission, ma'am.
Yes, I'm glad.
Yes, ma'am. Two things, ma'am.
Then let's find a solution then.
Two things, ma'am. Your lordship proposition is based on a futuristic event, on a what if both the applicants and the rest of the students, the applicant, could find a way to work together. What you present to you, your lordship, is what has occurred up until this event. Your lordship, if you look at paragraph 25 of the answering papers, we state that the students, through their general counsel, the university tried to engage the students to say, if this situation persists, we are left with no choice but to close the institution.
When did this happen?
Well, my lord,
That's the thing, you don't say it in the papers.
what we at least know that it happened between the times of this application and Tuesday, the 15th.
No, but I don't know that because you could have said it in your papers. You know exactly when you engaged with them.
My lord, student, it is a fact established in the following papers that such a protest commenced on Tuesday, the 15th of April.
3 days ago.
Any discussion related to the process at hand has to happen.
But what is the point that you are making?
The point
That you want them. So what does that do to the issue we are discussing? And the issue we are discussing is you've already accepted that it may not be correct to simply throw them in the streets and expose them to all sorts of dangers. You've accepted that. So I'm not sure how the engagement that has taken place answers or solves that problem in relation to the engagement that the university itself says it wants to do.
My lord, this goes to the point where the lordship makes a proposition that perhaps the two parties ought to meet to come up with a solution that will exclude the violent aspect of the protest.
Yes.
And my engagement in the lordship is that that has been done. And unfortunately, the situation is persistent. What one does not want is the occurrence of death and injuries occurring within the institution. Clearly, the measures that are in place and the protest at hand is not able to protect.
Let me ask you, have you made a case of a death or injuries that have occurred at the instance of the students?
My lord, again.
Have you made that case?
No, my lord.
You are not?
No, my lord.
Then why are we even discussing
No,
it?
my lord. What we're saying is the institution has a duty of protection to its property, students, and that of its staff members. And as it stands, it is not able because of the violence.
No, but what if you accept that it is not your case that the death you are referring to and the injuries that have happened have not been caused by the students, then I don't understand.
My lord, I would take you to the relevant paragraph, to which this is what you allege. Paragraph 17.
17.
Yes, ma'am. This paragraph is in reference, it is in reply or an answer to an allegation made by the applicants in their farm papers that what they've been engaged in is a peaceful protest. From the farm papers, the genesis of this complaint stems from the uprising of students because of dysfunction regarding the non-maintained residence and lack of compliance. It goes on further to speak that what students have been engaged in is nothing but peaceful. We then say, the allegations contained in this paragraph are denied. There was nothing peaceful with the mass action referred to herein. So we at least know that the mass action is that of the students. The university property was pelted with stones, security personnel were pelted with stones, university and private property was damaged. For example, a motor vehicle belonging to a staff member was banned beyond recognition. So we know that the mass action is by students, and it is resulting in this particular consequence.
Now, accepting all of that for a moment, that in even taking it further, when Mr. Ngunyana does not admit that it is his clients, the students, that did that, but for a moment accepting that it is the students who did that, what then is the way forward? Is it the solution then to say, when I leave this court, they must be out there and be on the streets?
The way forward, my Lord, is the constructive order by your Lordship to say, perhaps given a period of 48 hours to 72 hours to exit university premises, make alternative arrangements.
But that assumes that by that time, remember, this is the challenge. This is the challenge that I'm facing. If some of the students do not have money to go home where they belong, because I'm assuming that this is not the time that they ordinarily would go home, and Mr. Ngunyana complains that they were not given sufficient time to be able to arrange their affairs in light of the decision by the university to close themselves. Now the question then is, you've suggested 48 hours. And what I'm looking at is whether it is, are you arguing that it is not possible, it would not be correct, let me put it that way, for this court to find a way that seeks to balance this? Because I don't know really who has caused this damage, who has bent that vehicle. In the papers, you don't seem to be saying it is the students that bent that vehicle. You are simply saying it was bent. Now, I don't want to assume that it was bent by them. It is safer for me to say I do not know. But what is concerning is that it has happened, one can accept, during their protest. And therefore, there's something to be said about what may very well be some unlawfulness in terms of how the demonstrations were conducted. And the question then is whether it would not be in the interest of justice that, in light of this conflicting situation, and that is the students being thrown in the streets immediately and the university property being destroyed, the students themselves are interdicted as part of that process from engaging in violent protest, including the pelting of stones and all of those things, destruction of university property and all of those things, at the same time as the university is interdicted from evicting them. Would that not cover both sides in terms of ensuring that the dangers that they may very well face if they are thrown on the streets are ameliorated, so to speak? Because you've said, even at the university, you can't guarantee their protection. You are unable to protect them. Is that what we are saying?
What we're saying, my Lord, is that people have been injured, property has been destroyed, person has died on campus grounds during the mass protest.
So what should we do?
What I'm saying, my Lord, I hear what your Lordship is saying. I understood my colleague's submission to be along the lines that we're not given sufficient time for us to make the appropriate arrangements.
And you're saying 48 hours would be enough?
No, my lord. This was part of my submission.
Yes. Let me say this mistake, Kenukile.
Yes, Lord.
You intend in any event on your own papers to reopen, to let them come back on 5 March. Sorry, 5 May.
Yes.
Would it not be better to issue an interdict that interdicts the very students from engaging in violent demonstration between now and 5 May, so that the university property is protected, but also they are not thrown in the streets like that, whilst the student leadership and the university are trying to find, as the university says it wants to do, to find a solution to all of these things. Because while the students have the right to protest, they do not have the right to engage in violent demonstration. I'm sure they know that. They have no right to dare to destroy university property, and the court would have no difficulty in interdicting them from engaging in unlawful conduct. And the question then is whether we should not be finding a balance along those lines.
Part of the problem, my lord, to that is this. My lord colleague is a submission that says property has been destroyed, people have been injured, but students do not associate themselves with that particular.
You say I have a difficulty with that, and I engaged with him on that. You know you were here.
Yes.
Yes.
Which means, even if your lordship is to issue, in accordance with the version provided for the Mandela colleague, in accordance with the particular submission, even if students are to engage in a peaceful protest between now and the 5th of May, there may be some sort of violent element, but what is not submitting is that must not be attributed to students. So which means that even if one is to protest or picket, there may be a violent element. It even goes and says perhaps because of public, other individuals just getting involved in this particular situation. However, in that regard, let's say students in this regard were peaceful.
You see, Mr. Gerugele, the students live there. It can't be that they were to say to this court they would not be able to ensure that criminals and other people that want to destroy university property
that was the problem that the lordship had raised.
Exactly.
That if you're saying you're not the ones that destroyed university property, then it must mean that you allowed it to occur. That, my lord, was part of the consideration. If we say that it is not the students, or any other person can, because there's a problem.
Well, I thought Mr. Ngunyana went further to say he would be able to get that undertaking, but I'm not even looking at undertaking, I'm looking at interdicting in unlawfulness even by the students themselves. Because whilst they have a right to demonstrate, they don't have a right to destroy university property. They don't have a right to endanger lives and all of these other things.
My lord, let's look at the effect of that particular submission. Two things. If the submission is that it is not the students that dealt the damage to the property, it must have been someone else.
Well, I thought he said they don't know. He doesn't know.
He does not know.
Yes.
He thinks that he will not be able to advise to assist in the court in that regard. If that, my lord, is the position of my learned colleague, an interdict against students to say that we are not allowed to be any violent in a protest. This has been a suggestion by Mandela colleague that says that the damage that has occurred was not done because of the protest. It might be someone else. This means that the interdict itself will still not be able to protect.
But that's an assumption. One should not easily assume that these students would not want to obey court orders, but the university would want to obey court orders.
No,
I don't understand that submission. What are you saying?
My submission, my lord, is...
If you're saying an interdict may not protect, we are saying they would not obey a court order.
No, my lord, that's not my submission.
What are you saying?
My submission is clear. Two things. The submission of my learned colleagues, the violence, the possession of property must not be attributed to students. It might have been caused by any other person within the university. And the lordship is proposing an interdict against the students, not to cause any violence. And I'm saying, my lord, The students in this case are represented by Mandela colleague, who is submitting for the court to say it was not the students. If an interdict is simply going to go against the students, this means that university property, students and staff members will still not be protected from any other individual who is not a student.
In other words, you are saying you have no assurances that from the students themselves that they would work with the university ensuring that the criminal elements that destroy university properties do not do so.
As the status quo has shown us, if Mandela colleague is distancing students from the conduct that has destroyed university property and just students, that means that such has not occurred. And the suggestion that the proposal that will come into place, if your lordship, if Leonard colleague submission is that give us sufficient time to make arrangements, I'll be amenable to that particular order. To the extent
arrangements to do what?
To vacate the premises.
But how much time do you have in mind?
Well, my lord, it will be for what my Leonard colleague had. I don't want to bring the submission a okay before the lordship came into play. However, if the lordship would permit.
No, don't. Because
a discussion would have been a period of at least 4 days for the students to be able to vacate the premises of the university.
Yes.
In that one, an interdict operating between today and that 4-day period would suffer.
And if there is peaceful protest and no violence for the next 4 days or 7 days for that matter, you're saying they should still be evicted even if there is peace and quietness at the campus. The effect of an order that you suggest would be, in any event, even though the threat had dissipated and disappeared, they should still be evicted. And the student from Zimbabwe must go back to Zimbabwe and travel back on 5 May regardless. The student from Bizana must go back to Bizana and travel back regardless.
It's now trampling upon the lines of assumption.
No. You see, this is the thing. That's what the eviction will mean.
In effect, my lord, what the letter by the Vice Chancellor says is to say there are underlying issues that need to be resolved in between those times. And as it stands, we're not able to resolve them. One, my lord, has to safeguard the interest of the university and the interest of the students.
Can I ask you a different question? Mr. Mgunyana raised the question of the lawfulness of the eviction, and he says the council of the university authorized in specific terms the closure of the academic activities, the closure of the university. They said nothing about the students being evicted. And I did indeed read the chairperson's letter. He does not mention any eviction of students. Now, are you saying, in terms of the university statute, the closure entails the eviction?
Two things, my lord. From the reading of section 7, subsection 2, it says, without limiting the scope of paragraph 7.1, the council has the powers, functions contemplated in subsection 7 to 8, 2 below, and may, in accordance with section 68 of the Act, delegate or assign to other university structures, the Vice Chancellor or any other employee of the university, any of these powers and functions. 2, which is inclusive of the M.
Of what? What is M?
M, my lord, is order the closure of the university.
Exactly, that's the point. That's where I'm getting at. The university, he says the statute itself talks about the closure, the council talks about the closure, the students, Mr. Mgunyana says, close the university by all means, but don't evict us, because if you do, we will be in trouble. The question that I'm having for you is the authority for the eviction, or should I understand the closure to entail eviction? And if that is so, where should I get that?
Well, at section 7.2, we are told that the council delegates such power to the Vice Chancellor.
Power to close, that's
yes,
the point.
Power to close. It means delegate or assign to other university structures in the Vice Chancellor. So section 7.2 gives the council delegates powers to that of the Vice Chancellor. So if your Lordship assumes that the closure of the university in terms of the letter written by the chairperson of the council does not in its own encompass the eviction of students, then 7.2 tells you that the true delegation, the Vice Chancellor can close the institution itself.
Exactly, that's right.
And we explained in our affidavit that
yes,
one has to understand the nature of the institution, the primary reason as to why students are there for learning. And if that is taken away, then there is no basis for them to remain within the institution, because the core of the function of the institution is not okay.
Let me ask a different question.
Yes,
the students somewhere, they say, well, there is a reason for us to remain in the campus. That's what they say in the affidavit. They explain that some of them have submissions to make on the 30th of April. Some of them say they are supposed to be given internship that has not yet been done. They give dates. Some of them say there is graduation to be prepared for. And all of those are not dealt with in your answering affidavit. Or if you do deal with them, show me them.
That argument presumes that the only method of learning is
No. Let's go to your papers.
Let's go, my Lord.
To your answer. Where do you deal with that?
We deal with that, my Lord, particularly at paragraph 21. From a read after.
Just a moment. You deal with it at paragraph 21, you say?
Yes, ma'am.
At your paragraph 21?
At our paragraph 21.
Yes. Yes.
We say, my Lord, that the allegations contained in this paragraph are now. In the year 2020, the Walter Sisulu University, through a time of COVID-19 virus outbreak, where the university was forced to summarily close down. At that time, the university was able to make arrangements for online learning and for the continuous assessment of students in circumstances where students are at home. So we provide that there is a way to deal with this.
Okay, just a moment. Where do you deal with paragraph 21? Read paragraph 21 of the founding affidavit.
Let me go to paragraph 21 of the founding affidavit.
And paragraph 22.
I'll take it, you mean the first paragraph 21, because there's a repetition of the two paragraphs.
Page 18.
The ones, my Lord, that we shall have nowhere to go, should we be evicted?
Just stop there. Where do you address that?
My Lord, we address that where we say...
Remember, you are dealing with their paragraph 21
yes,
at your own paragraph 21. That's why...
We have dealt with this in this particular affidavit, where we deal with the issue of, apart from the denial, we'll deal with the issue of an alternative remedy. Where
is that?
That's the one, my Lord. That, my Lord, would be at where we note that there has been a repetition. That, my Lord, would be paragraph 26. That's the moment, man. Yes, paragraph 26.
You're 26.
Yes, ma'am.
Yes, I'm there.
We say there's another...
They must just go home. Now read further then.
The university is closed. There's no academic enterprise going on. Even staff members are not going to work.
No.
No teaching.
I'm saying read further at their paragraph 21.
Furthermore,
the respondents.
At page 20, paragraph 21, we shall have nowhere to go should we be evicted. The respondents know very well that the liveliness must survive, and also for means of transport.
Just stop there. Where do you deal with that?
Well, exactly here. Well, this is what the Lordship has to understand. For all of this to occur, it needs a functioning constitution.
No. Mr. Galula, help me here. They make this allegation, and the allegation is simply this, we rely on NFSAS to survive and for means of transport. For them to go home, as you say, they need transport. That's what they say in their papers. And I'm asking you, where do you address that?
Well, what we say in our affidavit is, at this point, the university is not able to operate. In order for, if one is speaking of the university must make alternative arrangements, where is that going to occur?
No, but this is the point about the question of whether in all of these circumstances, and considering the papers that I have before me, all of which are quite, do not assist much actually, is it not more practicable then? Because you are not, no way are you dealing with this. You see now, you are talking about a functioning university. In other words, because the university is not functioning, throw them in the streets. Let them sort themselves out. That they have no money, it's none of our business. Because the university is not functioning now, I hope you are not suggesting that.
If the argument is construed in that manner, it will be wrong. What we're saying is, the function of the university is not occurring. In fact, vice versa, the function of the university is occurring. Life is being endangered. Life has been taken.
No. We've made that argument. What I'm saying now, let's be practical. You're saying evict them. They say we rely on NFSAS to survive and for transport. And many students reside far away from Mthatha. Now, if, assuming for a moment that it is indeed true, and it is not difficult to imagine that it may very well be true that some students are from Durban, some are from Bizana, some are from Zimbabwe, as Mr. Ngunyana indicated. If that is true, and they say so before this court, that if you throw us to the streets now, the question then is it not a better alternative to then say, interdict them from engaging in illegal activities to enable the university to function? And in fact, even directing the student leadership to prevail upon its members to not behave and ensure that all of these illegalities are not taking place during their peaceful protests, because that is basically the problem here.
We tell you in our papers that what we are suggesting now has been done. The council has met with the student.
No, what has not happened is a court order ordering the students, to the extent that they are responsible, to ensure that illegalities are not taking place at the very institution in which they say they should not be evicted. And this is the point.
One of the operating words in the legislative position is to the extent that they're involved. My learned colleague stood up and said, we are not involved. That's the problem. When you seek to say, I will interdict, the same individuals who stood up and said, we are not involved. Who then gets to...
So what is the solution?
The solution, my lord...
is to evict them.
My lord, the solution is to evict students.
That's your solution?
My lord, hear my submission.
So as the in loco parentis, your solution is throw the children in the streets, let them sort themselves out. If they meet Mthatha criminals, it's because they misbehaved, and it's not your problem. As the university, is that what you are asking me to do? You are asking this court to close its eyes to the realities that crime is rife in Mthatha and its surrounds. And if it exposes some of whom are female students, they could be exposed to all sorts of things. And you are saying, for your safety as the institution, the compromise is for them to be on the streets so that the university can function very well. And who will then come back when they are killed in the streets? Well, maybe 10 will be killed in the streets and the thousands will come back. Is that the submission in a nutshell?
That would be a sympathetic argument.
That would be a what?
A sympathetic argument.
A sympathetic?
Yes, ma'am.
Yes.
I've not made that argument.
Yes.
Argument, my lord, when you're not sure it's said.
That's why I'm asking you for a practical solution.
Yes,
you keep coming back to saying, chase them away, evict them.
My Lord,
You are not saying
my
that.
Lord, this is what I proposed earlier on. When the Lordship said, what must happen after raising the school?
Let me tell Mr. Genugile, you are not going to convince me, at least not tonight, that I should throw somebody's child in the street tonight.
No, my Lord.
I'm not going to do that. Let me be very clear.
I understand the Lordship's position
Yes.
in that regard. Hence, what I proposed to your Lordship
Is what? 48 hours?
No, my Lord.
What?
My Lord, I indicated that
I have proposed, suggested to you whether some sort of a structural interdict that ensures that whilst they are interdicted and to the extent that they may very well misbehave, the university can come back to this court and say, listen, the student leadership has not prevailed upon its members. The members have continued to misbehave and destroy university property, or at least threaten it. We were assisted by SABC, otherwise they were on the verge of doing so. Please chase them away. That, in other words, the students themselves would have been disobeyed a direct injunction of this court.
what your Lordship doesn't address in that particular regard,
Yes.
what your Lordship doesn't address for the second instance, is any other person who seems not to be a student, as Mandela.
No, but you can't possibly, Mr. Genukele, say to me, I should issue an interdict against an unknown person when the case before me is for students. I'm not sure what you want me to do, because if your case is that it is the students that are doing these things, then they should be interdicted. But then don't tell me then about the other people. It may very well be that tomorrow the staff of the university will go on strike. That's a different case. That's not before me. Not now, at least.
I considered the proposal that your Lordship had come up with, and I pointed out that part of that proposition, through the Lordship's engagement with Mandela colleague, presented a particular problem where Mandela colleague said, students distance themselves from...
Let me say this.
Before your Lordship,
Yes.
can I make this submission? As part of what your Lordship's termed as structural interdict,
Yes.
I propose an alternative,
Yes.
which would say that in a period of 5 days, for you to make alternative arrangements.
No. How about a period? Wait. How about a period of 5 days during which you will not be evicted if you do not allow or cause damage to property as you demonstrate peacefully? In the event that you don't do that, then an eviction order will become effective.
That precursor was absent in the initial.
No, I'm making it now.
Yes.
We're
All right, those are live visuals from the Mthatha High Court in the Eastern Cape that is currently hearing an urgent matter seeking to interdict the Walter Sisulu University from evicting students after the institution resolved to close campus effective immediately. That was the 18th yesterday. Now, this is, of course, following the protest during the week that saw one student lose his life. The judge, as you've heard now, has been asking very pointed questions to the legal representative of the university. I believe we have our connection back. Let's take you back to those live visuals in court.
That cannot be correct. Even the unfortunate killing of that student cannot possibly be a justification for further lives to be lost. It cannot be correct.
I just want to capture your Lordship correct.
Yes.
The proposed order comes in this format. One, students, staff, or students are interdicted from conducting themselves in a violent manner.
Remember, staff is not before me, so let's not talk about that.
No, that's why I said
Okay,
in the reading
all right,
of that
all right.
particular order.
Yes.
Students are interdicted and restrained from conducting themselves in a
Yes.
violent manner, the destruction of property and otherwise.
Yes.
Then one qualifies that particular.
Do you need protection from her?
No, ma'am.
Okay.
No, ma'am. Your Lordship would know me too. About who I need.
Yes.
My Lord, I've come to the realization that what the Lordship is proposing is an interdict against the students being restrained.
Yes.
However, that order must then be qualified that present any violent destruction of property at any given point in
Or
time,
threat to human life.
threat to human life,
Be
threat
that
to
of
property.
students or even staff, anybody, university community, all of them.
Yes, Madam.
Yes.
I would understand that, Your Lordship.
Yes.
Yes, to be the order that you're seeking.
Yes.
So not seeking, my Lord, the proposal.
Which one?
The one that we've just discussed.
Yeah, but you are refined with Mr. Ngunyana in terms of how properly to set it out. But I'm just telling you now where my mind is at.
Yes, ma'am, I would understand that. Even if you were to make an argument
Yes.
that is not the case where Your Lordship will still be amenable, will still stand still on that particular.
Even if you were to argue what?
That is not the case for Your Lordship.
For who?
For an interdict against the students. However, that
So you're saying,
Madam, my Lord.
sorry. Are you now arguing that even as I may interdict the university from evicting them, there is no case for them, the students, to be interdicted? Is that the submission?
No, this is my submission. This was coming along the side of what the case of the student is. And
Look, I'm happy to grant the case of the student as it is, if that's what you want. But I thought you saying, how about addressing university concerns? And Mr. Ngunyana says, in his papers, notes of motion, he has mentioned what he calls further and alternative relief, relied on some case law to say how far I could go. But what I'm getting at now is this, whether it would not be in the interest of justice and be more practicable to say, the students are here now before me, and whether or not you have a difficulty if they, on their own papers, are interdicted from engaging in unlawful conduct, essentially, because that interdict against them will be nothing more than that, than to say they should not be engaged in unlawful conduct.
My Lord, part of my submissions earlier on, I understand the constructive of the taking, and I wish to discuss that with my learned colleague. Part of what my submission was,
Yes.
was what is before you as it stands is not that order. However, Your Lordship has given an indication that despite the legal discrepancies in their papers, despite the what one may term as procedure into what the court needs to construct before it, Your Lordship is taking a position under I will say not the pretense, but under the term interest of justice.
Would you not say Rule 612 allows me to extend it that far, to say, despite all of these other challenges with their own papers, I could condone in the interest of justice and do what is practicable? Because ultimately, here, whilst legal niceties can be engaged on, and I love them, trust me, as you know, but we have to be practical about what we are faced with. And what we are faced with is the possibility of young children being thrown into the streets. And you agree on behalf of the university.
All right, the live proceedings from the Mthatha High Court in the Eastern Cape, where they are hearing the urgent matter seeking to evict students from the university, the Walter Sisulu University. Quite a lot we've been hearing from the judge there. Pointed questions, as stated just a bit earlier on, that the judge has actually asked the representative of the institutions that where exactly are the students meant to go? If the students currently are being evicted or the campus is being closed purely to ensure their safety, would that not defeat the purpose if they're immediately asked to evacuate the university, that would then defeat the purpose and expose them to even further danger. And we heard there from the representative stating that actually at this point the situation is untenable. They don't even believe that an interdict that would prevent the students from vandalizing property would be effective in this respect. We've got our reporter there that's currently on standby, Fundiswa Mhlekude. She's been monitoring the proceedings and will give us a summation and also reaction post just these hearings. We've seen and caught a glimpse of Abatembu King Belekaya Dalinjebo was also there in the court gallery. So most certainly we'll bring you more of these live proceedings.